Good morning. I think we're ready to begin. We're here in the matter of the estate of Thomas K. Coma. It's our case number CV140477. The appellant is Alice Coma and Arthur Peter Walter is the appellee. Each side will have 20 minutes for argument, and counsel for appellant are responsible for reserving any time you wish for rebuttal. We have conferenced the matter this morning. We've reviewed the briefs and we've discussed the issues and are looking forward to hearing from you this morning. With that, you may begin.
Thank you.
Did I mention, please announce your name when you come to the podium. These proceedings are being recorded.
Andy Jolly, attorney for appellant Alice Coma. If it may please the court, my client Alice Coma had planned on being here today. She is elderly, and with the weather as it is, she was not able to make the drive from Lake Havasu. She apologizes for not being here. We are here requesting de novo review because this is a mixed question of law and fact. In essence, we feel that the trial court misapplied the case law to the evidence in a manner cautioned against by the Macaulay, Westfall, and Vermeesh cases, such that the trial court abused its discretion at several key points. There were discovery issues that we believed would have bolstered our case as outlined in our briefs. However, I'd like to focus on the facts as presented at trial and applied to the established case law. We believe the trial court fell victim to the caution as outlined in Westfall. Quoting, "Presumption is an arbitrary conclusion which the law says must be drawn from certain facts." Recently, the Supreme Court ruled in Mullen v. Brown that a presumption is not evidence of anything and only relates to a rule of law as to which party shall go forward and produce evidence sustaining a matter in issue. A presumption should never be placed in the scale to be weighed as evidence. Unquote. Respondents rested their entire argument on this presumption, and the trial court bought into this idea that the presumption of the documents was evidence of their validity, making it virtually impossible to overcome them. We believe the testimony and evidence did in fact overcome the presumption, and the presumption as outlined in case law and statute does not intend to establish an unclimbable mountain. First, testimony capacity as outlined in Vermeesh. There was no testimony on the record that any of the three elements were established. In addition, Mr. Coma was a very sick and confused man who changed his mind often, having been in and out of the hospital and hospice facilities for several months. By all accounts, he was on his deathbed, and this was his last conscious act. In the response brief, they argue that their witnesses and two hospital employees established the elements. We believe this failed to do so. What was presented needs to be weighed with Mr. Coma's medical status, and almost more importantly, what was absent from the testimony.
Counsel, wasn't there also evidence, though, that Mr. Coma had discussed doing this prior to the day before his death?
That's a very important timeline to establish, Your Honor. On September 23rd, there was what is known as a family or interdisciplinary meeting. And that was the day before, that's actually 2 days before his death. After that interdisciplinary meeting, the doctors decided end-of-life comfort care would be the only thing provided.
But didn't he talk to people even before then?
The only person that testified that he had talked to about that was the respondent, Mr. Pete Walter, who we referred to throughout the trial, and I will refer to here today as Pete. That's kind of the common way to respond.
So was there evidence in the record that Mr. Coma had talked with other people before he was ill about changing his estate so that more would go to the church and less would go to Alice?
I believe that the only testimony that was provided, there was a friend, Charlie Foster, who came, and Charlie Foster during testimony said that he had heard Thomas Coma mention that he may want to shift, as you were saying, Judge Howe, the the amount given from Alice to some to the church. But
the reason I raise that, though, is isn't that valid evidence to consider and give whatever way the finder of fact believes should be given to it?
Well, I believe that the trier of fact has to weigh all of the evidence. And in addition to that evidence, there was also evidence that Mr. Coma was in and out of hospice and hospital care these last few months of his life. And there was no evidence presented that prior to that time he had ever discussed this with anyone. There seemed to be, and that's what the...
I'm sorry, but the question I have about this case is, what is the appropriate standard of review? You're talking about the evidence, and it seems like we should afford some deference to the finder of fact on these issues, and who are we to change that?
We anticipated that would be a question you'd have, and the response I would give is Macaulay, Vermeesh, Westfall, and several other cases as cited in the brief did exactly what we are requesting you to do. We're requesting you to take the evidence that was presented at trial, even what the trial court, how the trial court weighed it, whether you agree with him or not, and then apply it to the current case law. And the case law as written doesn't seem to fit the facts as presented.
Which case law? Sorry.
No, go ahead.
The main cases we're relying on are Vermeesh, Macaulay, and Westfall. But we cited over 20 cases in our briefs.
Let me ask you, though, in a few minutes ago and now more recently, you've talked about weighing the evidence, and I understand that. But isn't that what the trial court did in determining both competency and addressing undue influence? And particularly, just for undue influence for a second, if I read the record right, the court at the end of the hearing, at the end of the evidentiary hearing, sort of marched through the Macaulay factors, said, hey, this is a close case, and some cut one way and some cut the other, and here's my decision. And isn't that what finders of fact do, and isn't that worthy of deference from this court?
It is worthy of deference, but I think what we're asking for is that the information that was given to the trial court, the evidence and the testimony, do not support the conclusion that was drawn. I don't want to get caught up in the weighing of the evidence as much as we're asking what evidence was presented to be applied to the case law.
But isn't that sort of a sufficiency of the evidence argument? And I don't get that flavor from your briefs.
If it is a sufficiency of the evidence,
no, and I'm asking. I'm not telling. It seems to me either it's a reweighing, which this court doesn't do,
right?
Or from what you described, it's a question about the sufficiency, and I don't see that in your briefs.
We believe the evidence that was presented at trial was sufficient to draw a conclusion. What we disagree with is what the conclusion was drawn.
And I understand that, and I understand why you would be disappointed with the trial judge's outcome. But it seems like that's such a factually intense decision based on credibility assessments and weighing assessing factors. In Macaulay, for example, those aren't elements, they're factors. And the trial judge, I thought, was very upfront with the parties, saying some of them cut one way, some of them cut the other way. Here's my decision. Isn't that the scrutiny that Macaulay demands and that we're entitled to defer to?
I think Macaulay demands more than that, and I think that's what we're asking this court to do, what Macaulay did. And reweighing the evidence isn't what Macaulay called it, but in essence that's somewhat what they did. But you as the Court of Appeals have to decide how that's done. But in Macaulay and Vermeesh, they both went back and looked at what evidence was presented, and then they applied it to the case law. And Macaulay, I mean, that's a 1960 case that's still very good case law. And we believe where the trial court erred was in justifying away the factors that he found. And you're exactly right. He went through and he said, you know, with regards to our side, we think you found this, we think you found this, I think you found this, but I justify it away in these ways. And I don't think Macaulay allows him to do that. And I think that's where the de novo review of mixed law and fact come into play.
What about Macaulay suggests to you that our review should be de novo of that determination?
De novo is not just from Macaulay. We didn't rely on Macaulay for our de novo review. We relied on Armada v. Cardenas, Cal X Trey versus WVSV, and City of Phoenix Schuyler, and also Army versus Bryson. De novo has to come from a series of places, not just Macaulay.
It isn't just de novo. We review questions of law de novo, but we never review factual determinations made by a lower court de novo. Is there some authority for us to review factual determinations made by the lower court? You're saying that's from Macaulay?
Well, I believe the way Macaulay did it is that's basically what they did, but they didn't call it de novo review. I don't really know what to call it at that point. But
let me ask you, would you, in my understanding, if you wish to leave to your briefs the jury trial issue, that's fair enough. I'm not looking to script how you use your time. But if instead of the second judge saying, no, there's no jury trial right, the judges hadn't been reassigned, and you had a jury trial, and the jury delivered a verdict with the same conclusion, would your position be the same, that Macaulay still requires a sort of uber scrutiny of the factual findings? It seems to me that that's the black box, and we don't go in that black box.
I do believe that the way Macaulay outlines how they went back and looked at the facts and testimony as presented would also require the same scrutiny, whether it was to the trial or to a jury.
How would we do that with the jury verdict, which would simply say yes or no, not give the more expansive analysis that the trial judge gave you here?
Well, I think the question would then have to be, based on the facts and evidence presented, was the yes or no justified?
Well, and counsel, it sounds to me that what you're basically arguing is the sufficiency of the evidence, that the evidence doesn't prove what the trial court found and approved. And that's not exactly what you were arguing in your briefs.
That's not the way we saw it. What we saw was the evidence that was presented applied to the case law didn't justify the conclusion that was drawn. But the evidence that was presented was sufficient to draw a conclusion. So I guess that's where...
Well, so you're arguing the trial judge came to the wrong conclusion based on the evidence, and I don't know how we can really take issue with that.
Well, again, Macaulay gives us the opportunity to have the Court of Appeals review it and apply the factors, and that's what we're asking for. We want what Macaulay got, and we believe that that's what we're here for. I'd like to reserve the rest of my time if I could.
Good morning, Your Honors. My name is Jeff Coughlin, law firm of J. Jeffrey Coughlin, PLLC, from Prescott, and co-counsel with Eric Chester, representing the appellee. We're going to divide our time, and I'm going to address what's mentioned in our briefs in the table of contents as arguments 5, 6, and 7, having to do with the attorney-client privilege, motion to disqualify Mr. Chester as counsel for the decedent, and the motion, post-trial motions 59 and 60, along with the jury trial issue that was raised in the appellant's opening brief. So in that order, I would like to start with the attorney-client privilege and the motions to disqualify Mr. Chester as counsel for the decedent. This started at an early point in the case, at which point I came into the case simply because there was a possibility that Mr. Chester might be disqualified. So the attorney-client privilege issue is something that the court addressed in denying the motions to disqualify, and also in a motion to compel Mr. Chester to testify in a deposition following his first deposition. So with that first issue on the platter, so to speak here, the court addressed the first motion to disqualify Mr. Chester by saying Well, this is the attorney-client privilege you're talking about, and we take that seriously. But we'll give you another chance. Develop your case, conduct some discovery, determine whether or not Mr. Chester is a necessary witness, and then maybe we can revisit this. At his deposition the first time, Mr. Chester was asked a number of questions, a broad array of questions concerning conversations he had had with the decedent, conversations he'd had with who ultimately became the personal representative, Pete, both before Mr. Coma retained Mr. Chester, after Mr. Coma passed, and before Pete retained Mr. Chester. All those questions were asked of Mr. Chester in his deposition. He asserted the attorney-client privilege to most of those questions and refused to answer. During that process, counsel for Alice Coma essentially gave him an ultimatum, Mr. Chester, saying, if you don't answer the questions today, I will file a motion to disqualify you as counsel. Not something that's taken lightly in the midst of litigation to try to disqualify counsel for the other side for some sort of tactical purpose, but that's what was done, and he made true on his threat, so to speak, and moved to disqualify him. As I said, it was denied the first time. Months later, a motion for an order to show cause to have Mr. Chester disqualified was brought to the court, and to have him compelled to testify to answer all the questions that he had not answered at his first deposition. Now, Judge Mackey was the presiding judge at the time, and he had taken the case over from Judge Wolfinger, the first judge, and he said, well, you didn't provide me with a transcript, so I can't exactly tell you, I can't tell what questions you're asking me to force Mr. Chester to say, to answer, so that's a problem. You haven't shown the court that he is a necessary witness, that's a problem. And most importantly, you have asked you've asked me as trial judge to compel Mr. Chester to testify and answer a broad array of questions. Things having to do with conversations between him and the decedent, clearly covered by the attorney-client privilege, all questions that were asked at the deposition, all questions concerning conversations with Pete, no matter when. And this wasn't broken down so that the court could say yes to some of these, no to some of these. This was all questions concerning conversations with Pete, no matter when they happened. All questions regarding documents that Mr. Chester witnessed as a notary, not necessarily limited to this case. All questions concerning affidavits in this case, any statement or any action attributed to Mr. Chester in this case from day one. So it was this broad array of questions that the trial court had a problem with and was just not willing to waive the attorney-client privilege. In her reply brief, Alice Coma says essentially that the attorney-client privilege is arbitrary and that it's really, we are quibbling over the verbiage in the request that she made to the trial court. It's actually that verbiage that the trial court was very concerned about. It was too broad and was not willing to do the work essentially for Mrs. Coma in trying to get the information and establish that Mr. Chester was a necessary witness. So he denied the second motion to disqualify, denied the motion to compel Mr. Chester to testify. And that is the issue as far as that particular argument goes. I don't know if you have any questions about this, and if you don't, then I'll proceed to the next.
It really turns on the determination of whether he was a necessary witness, correct? I mean,
Yes.
there are a lot of other things swirling around, confidentiality, attorney-client privilege, other things, disqualification, but the necessary witness is the hook.
I think it is, and the trial court decided that based on what had been developed in the case, even the appellant had determined that Mr. Chester was not necessary because they had discovered information. They took Pete's deposition, and they could have taken multiple other depositions. But the fact is, there were witnesses that witnessed the signing of the will. they could have been deposed, and they could have provided the same information that was necessary from what they deemed necessary from Mr. Chester, and did not. So the trial court said, you had a chance. You had
There
a
could
couple
be
of chances.
other information other than just witnessing, signing a will, though, certainly going to his
Oh, sure.
testamentary capacity. But you're suggesting that there were other witnesses, and that is the critical inquiry is, was he a necessary witness? And if there are other witnesses that can assess his testamentary capacity, then the attorney is not an essential or necessary witness.
Absolutely, and those witnesses were identified. Some of them actually were deposed. Dr. Missy was a hospital doctor, and Jill Logan was an administrator at the hospital that actually questioned Mr. Coma when it was determined he was looking for an attorney to actually prepare these documents, and they did testify, and they were persuasive to the trial court, at least, about his mental condition at the time. But the issue about being a necessary witness, first of all, to disqualify an attorney on that basis doesn't mean that you disqualify him pre-trial. It means he cannot testify at trial, but doesn't mean that co-counsel can't continue with the case with Mr. Chester sitting next to him. He just can't testify if he's a necessary witness, he can't actually be the advocate at trial. So that is the position that we took, and Judge Mackey decided the second time to deny the motion to disqualify, and the motion for an order to show cause to compel him to testify again, based on this verbiage, which Alice Coma is saying that we're quibbling over. It's actually saying that the trial court was quibbling over the verbiage. The trial court was very clear that the verbiage was too broad. Concerning the post-trial motions, Rule 59 and Rule 60, I'm sure the court's had the opportunity to read the motion that we filed for a limiting of the issues, and this court said in response to this that the appellant could not raise any issues related to the Rule 60 motion, and they did, and they in their appellate brief. All of the Rule 59 issues and arguments are related to the Rule 60 issue, which they were instructed not to raise. So I don't believe the court has jurisdiction over the Rule 60 argument that the appellant is making now because it was excised from the case.
So your position that the trial court's Rule 60 findings are preclusive to the extent they're inconsistent with the Rule 59 argument that clearly is in front of this court?
The Rule 59 argument is in front of the court. That motion to limit the issues on appeal was denied in part, granted concerning the Rule 60 issues, and actually deferred to this panel from the one judge that ruled on the motion, saying we're going to leave this for the panel. Doesn't mean there's jurisdiction or there isn't, but leave it for you. In our opinion, the notice of appeal was filed, the post-trial motions were filed, and this court issued an order stating if you want to appeal the decisions on the 59 and 60 motions, you must amend your notice of appeal. It was not done. The notice of appeal was restated. It did not refer to the post-trial motions, and so it's the appellee's position that the 59 and 60 motions have deprived this court of jurisdiction because they failed to amend their notice of appeal to include those.
Well, but not for 59, right?
The Rule 59 motion was not a part of the restated notice of appeal.
So your argument is that both for 59 and 60 we lack jurisdiction?
Yes.
Okay.
And simply, well, for this reason alone, this court ordered that following the decision of the 59 and 60 motions, that the appellant had to file an amended notice of appeal, which they did not. The jury trial issue. I'm going to be quick here. I want to give my counsel, the co-counsel, the ability to present his case and answer questions that you had many of concerning the appellant's presentation. The appellant is arguing that that she was entitled to a jury trial because the first judge that had this case set it for one. Now, that issue was not raised in the trial court at all. The issues that were raised concerning a jury trial in the trial court had to do with equitable issues. Is a jury an appropriate trier of fact in that situation? But on appeal, she says, we were set for a jury trial by the first judge. The second judge said, no, it's a bench trial, and therefore we are entitled to the jury trial. So it's raised for the first time on appeal. It was not raised in the trial court. So she's waived that argument and abandoned the arguments that she made in the trial court concerning the entitlement to a jury trial. So 2 issues, waiver and abandonment on the jury trial issue. And that is my presentation for my issues.
Counsel, let me ask you on the merits of the jury trial. As I read the appellant's brief, they're arguing that it was an improper horizontal appeal, not that a substantive right to a jury trial was denied.
Okay, so a horizontal appeal
if
being...
we were to address the merits of that argument, I understand your position is we shouldn't.
The equivalent of a motion for reconsideration, really. In this case, it was a trial judge, the first trial judge that set it for trial in, I think it was 8 or 9 months later. And then that judge resigned, and the presiding judge took over the case and scheduled at a scheduling conference. Look, these are the issues. I'm going to set this for a bench trial in X number of months. And there was no objection to the jury trial set or the bench trial setting on the basis of it previously having been set as a jury trial. In fact, the court said, look, I understand that you have issues with this, whether there should or should not be a jury trial. I'll give you an opportunity to brief it, and the appellant did. At the end of that process, briefing on both sides, the judge decided this is a jury trial. This is not a jury trial type of case. We're setting it for a bench trial. So I don't consider that to be a horizontal appeal. I consider that to be an administrative process in the trial court where one judge takes over from the other, reschedules the case, scheduling orders, deposition, discovery to be completed by certain time frames, and including designation as a jury or bench trial. And that's what this court did. Any further questions? If not, I'll let Mr. Chester proceed. Thank you.
If it please the court, Eric Chester, co-counsel for Arthur Peter Walter. I want to start by quoting what the trial court said, sort of summarizing its opinion. This was the September 8th, 2014 minute entry when it ruled on the post-judgment motions. The court was convinced that Mr. Coma was fully aware of his estate and what he wanted to do with it without undue influence from anyone. That sort of summarizes the whole matter. Now, I'm not going to rehash all the evidence presented at the trial. You've read the briefs. We put that out in detail. I don't need to bore you with that. I may comment on some of the factual issues raised in the reply. But Alice's lawyers essentially disagree with this court's findings and its ruling and think that that in of itself is enough to constitute court error. As your questions show, you're aware otherwise. The legal standard is, was there evidence presented to support the findings and the ruling made? And in looking at that evidence, we look at it in a light most favorable to sustaining that ruling. And if there are any, I'll call them holes in that ruling, perhaps not specific findings made, it's this court's job to look at the evidence. If any evidence was presented which would fill in those holes to sustain the ruling, it should do so, as long as evidence was presented to do it, and it's not contrary to the stated rulings.
Counsel,
Yes.
do you agree that there was evidence presented going both ways on the issue?
Some evidence, but not very much, in my opinion, and I think the court agreed with that.
On which issue you're talking about, undue influence or testamentary capacity, or both?
I'm sorry, that the court, that there was little evidence presented, you mean?
On which issue is my question? On testamentary capacity or on undue influence?
Frankly, both. Testamentary capacity, I thought there was little, if any, true challenging evidence that was presented. And as they argue on their appeal, they seem to argue an absence of proof that he did have testamentary capacity, which goes back to his argument that he made earlier here today regarding presumption. Apparently presumption means nothing to counsel. Our case law and our statutes say otherwise. 142712D specifically states, if you're going to challenge your will for testamentary capacity or lack of testamentary capacity, if you're going to challenge a will for undue influence, it is your burden to prove that. Pete doesn't have to prove testamentary capacity, yet that's what she seems to argue in her appeal. In the reply, there was a line about how it was not conclusively shown that Tom's mental competency could not have declined between September 22 and 23. Well, that's not Pete's job to do. It is Alice's job, if she's going to challenge testamentary capacity, to show, if that's her argument, that his competence did go down, but she doesn't. She makes could have, might have, but instead sort of switches the burden of proof and says, Pete's got to show this. Well, Pete doesn't have to show this.
Counsel, if the trial judge had made the contrary ruling.
I'm sorry, Your Honor, I'm having difficulty here.
If the trial judge had made the contrary ruling and found that there wasn't testamentary capacity, would you be here today appealing?
Honestly, no, Your Honor, because we all know the trial judge, any finder of fact, has great discretion. And if there's any evidence to support it, that's enough. Your job here today is not to second guess why essentially they came to the conclusion they did, as long as the evidence supported it. So, yes, I would agree. If the judge had found the other way, we wouldn't be here today, because that's the province, that's the job of the trial judge. There was a question made when Mr. Jolly was up about Tom discussing changes to his estate plans, and I believe he misstated that it was never discussed before Tom was hospitalized, and that's not true. As the trial transcript shows, and we made reference to it in the statement of facts, Mr. Foster, who met Tom in March of 2010, over a year before he had his fall and his start of hospitalization, said that Tom almost immediately started complaining about Alice, and by that summer of 2010, Tom was already talking about changing his estate plan. So I did want to clarify that point that was raised earlier. And, you know, Macaulay doesn't specifically state that this is a question of law, this is something to be renewed de novo. In fact, it states the opposite. Macaulay and the cases afterwards clearly state whether or not undue influence existed is a finding of fact. I think my time is up, so thank you.
Thank you.
Your Honors, in the brief second I had to sit down, I went back and looked at City of Phoenix v. Geiler. And in that case, the court said, "It is our final responsibility to determine law and policy, as it becomes our duty to look over the shoulder of the trial judge and, if appropriate, substitute our judgment for his or hers. This process is sometimes, unfortunately, described as a determination that the trial judge abused its discretion." Or, I'm sorry, his discretion.
What was the nature of that appeal?
Do you mean what was the outcome of it?
That wasn't an estate challenge.
It was not. It was not. And it was remanded to the trial court decision regarding a Rule 60 issue. But I don't believe that's the substance we're relying on. We're saying that that's what we're requesting. With the limited time left, I'd like to focus on Vermeesh. I think Vermeesh is a very important case for us. And we would argue that there was no evidence presented at trial that the three elements of Vermeesh were met. The trial court seemed to rely mostly on Dr. Missy's testimony. However, we believe it gave weight to some things from Dr. Missy, but ignored other testimony from Dr. Missy. As I mentioned before, there was this...
What indication is there the trial court ignored evidence as opposed to rejecting or just finding it wasn't as persuasive?
Well, in its ruling, it didn't mention at all that Dr. Missy said after the interdisciplinary meeting the day before, Dr. Missy was asked specifically, would you be comfortable with anyone changing any documents of significance? And he said no. Because after that point, the decision's been made. This person's going to die.
Is it the trial court's obligation to comprehensively summarize each portion of the evidence in coming to a ruling?
No, but Vermeesh requires a legal standard to be met. And our argument is that legal standard was not met. The trial court seemed to rely on Dr. Missy, but Dr. Missy, he's a medical doctor. He's not an attorney or someone establishing a legal standard. The trial court relied on Jill Logan, who's the ethics nurse at the hospital, and she testified it was not her job or her responsibility to establish a mental capacity. And then there was the actual witnesses in the room. One was Mr. Chester's paralegal, so she could not be deposed or testified. Or she did not testify. One, it was discovered, is Mr. Chester's longtime live-in girlfriend, and you read the briefs. You understand what that is. And the other was Charlie Foster. Neither Charlie Foster or the longtime girlfriend established that Mr. Coma knew the natural objects of his bounty, the nature and extent of one's property, and the ability to understand.
Why didn't they? If Mr. Foster is talking about conversations that he had with Mr. Coma in which he indicated his desire to change beneficiaries of his trust and will, why isn't that relevant evidence?
We're talking about two different times, Your Honor. Mr. Foster said that previous to this, and I believe it was after Mr. Coma was in and out of hospice care, but at some point during that time, Mr. Foster visited Mr. Coma, and he said, I'm thinking about giving some money to the church and less to Alice. That was after he was already sick, but before the actual signing. And the Vermeesh requirements are at the time of signing, the person has to know those three elements. And so Mr. Foster said he recognized who I was. Well, that's not establishing the elements. And then the other testimony was...
What burden was it to establish those elements?
Well, that's an interesting question because the burden was put on us, but we think that was an error as well. We filed a motion for summary judgment. There was a cross motion for summary judgment regarding whose burden it was going to be. And the court decided that Pete was not a beneficiary under the estate documents. And we believe that's in error. If that's
how was he a beneficiary?
He was at one time a paid clergy member. He was a lifelong devotee of the church. He moved his family several times because of the church. When he moved to Prescott, he was paid for the job he did, and then his testimony was he did the same job but then was not paid for it. His wife was a paid employee of the church. And also just being lifelong devoted members of a church that go every Sunday to everything, any money that the Potter's House Church received, he benefited from.
Well, he was not named as a beneficiary in any of the documents, correct?
He was not. But if that's I don't think there's any case law that says that that's what's required. And honestly, Your Honors, we tried to flush that out from case laws. What is a beneficiary and what isn't? And there is not great case law on it. But if a person benefits from what is given, are they not a beneficiary?
Can I ask you just to clarify, is it your position that Potter's House was the beneficiary, which it was, and that Walter was an agent of Potter's House, or that Walter was the beneficiary, although Potter House was listed as the named beneficiary? Because those seem inconsistent, and I'm not quite sure what your position is.
Our argument is that Pete was an agent of Potter's House,
Okay.
and as an agent, he directly benefited from anything the church received.
And that issue was tried to the court, and the court rejected it, correct?
Well, it was tried through motion. It was a motion practice.
Okay.
So, did you present evidence that that Pete was acting as the agent of Potter's House to get Mr. Coma to donate his estate to the church? So that was a job that the Potter's House authority gave to Pete.
Yes. There was evidence presented that Pete was the only connection once Mr. Coma went into the hospice and hospital facilities between him and the church. He scheduled meetings, I believe, twice with the pastor of the church. He gave information back to the church from Mr. Coma. There was a connection there. Also, Pete was the one who arranged for the meeting with Attorney Chester. He was the one who told Attorney Chester what was to be in there. There's no testimony in the record that Mr. Chester ever met with Mr. Coma prior to the actual signing.
But is Pete acting on behalf of the church at that point, or is he acting on behalf of Mr. Coma?
Well, we believe Mr. Coma's mental state did not allow him to have his own free will at that time, and Pete seized upon that to act on his way. The Vermeesh elements are very important. And in its ruling, the court said it's close. He said testimony to capacity is close, undue influence is even closer. It's our argument that in a case like this, it can't be close. If this is what's going to happen on his deathbed, he's going to change his documents. It needs to be clear that the Vermeesh standards were established and the Macaulay factors were there as well, in the favor of the person changing them. We don't believe that was happening, and we're asking for the same review as Macaulay. Thank you for your time.
Thank you, counsel, for your argument. We will take this matter under advisement and issue a decision in due course. And with that, we're adjourned.